Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Recently, a local criminal defense lawyer was thrown in jail for contempt by a judge. So this guy is a colleague of mine. I know him. But let's go through and have a look at what happened, because this transcript is a little bit crazy and I want your thoughts on it as well. So let me know in the comments section what you think, but I'm going to give you a little bit of my thoughts as we go. Okay, so I'm starting kind of in the middle because basically I've cut out a lot of the introductions, but the court says, so this is the matter of Randy Van Hel, information ending 951 for trial continuation, Mr. Lebesis. Mr. Lebesis is the lawyer who was jailed. So Mr. Lebesis says, yes, that's correct, sir. My friend and I were just discussing an issue. We were just going to request this matter just... And you can see the court interrupts him to say, what is the issue? Well, sir, I think we've run into another snag here regarding what is the issue. So he can't finish a sentence here without the judge interrupting him to get his word in there. And he's not being allowed to finish even a complete sentence. So he says, I need the officer, Mr. Hill, before the court. I haven't seen him. My understanding. Have you subpoenaed him? Once again, the court is interrupting him. He's not allowed to finish a complete sentence. He's just getting interrupted constantly. So he continues, there was a subpoena that was prepared through the court, as I recall the file. My friend, through conversation with my friend, Mr. Ellis, had agreed to produce that officer, is what I understand. Now, in Canada, when we say my friend, we're referring to opposing counsel. That's the tradition in Canada. And it's polite, it's appropriate, so he's referring to the Crown prosecutor. The court says, I don't have that on my notes. And then the Crown says, I don't know if I necessarily agree with that. So Mr. Lebesis raised the issue before the court that he'd asked for Constable Hill, so I did look through the docket notes. I have a note from Mr. Ellis from the August 7th court appearance, and it simply says, adjourned to November 8th, Justice Yake is seized, going to subpoena Constable Hill as a defense witness. Okay, let's break down what's happening here. There is a police officer, Constable Hill, who the defense wants to call to the stand to testify, to provide defense evidence. So the court is concerned as to whether this guy has been subpoenaed. But often when you're dealing with a police officer, as defense, often you'll ask the Crown if they're willing to subpoena that officer for you. It sort of saves time, it's collegial, but also it prevents them from having to, normally you'd have to, if you're looking to subpoena a witness, you might have to track down where they live. And typically the Crown doesn't really want you trying to track down where a police officer lives for, their own reasons. So the dispute here is whether or not this particular officer was subpoenaed by the Crown and whether they'd given an undertaking, a legally binding promise to the defense that they would subpoena this witness. Mr. Ellis is another Crown prosecutor. This was happening sort of while the matter was in pretrial motions and sort of docket appearances and so forth. So again, you see he says so, and the court goes, who was going? And the Crown says an interpretation of that is he may have offered to under, and the court says, who was going to subpoena? And the Crown says, I don't know. So the court says, it is a defense witness. The defense should subpoena the witness. And the Crown replies, I agree, sir. I think it is fair that he can rely on a Crown undertaking that they're going to do it for him. I'm not sure that's what I have here. Now, keep in mind, Mr. Lebesis was trying to ask for something, but he never was actually allowed to say what he was asking for here. He's going to manage to get that out shortly. Court says, was that said on the record, Mr.? And Mr. Lebesis says, I don't have those notes. I don't have the transcripts. I don't have the endorsements before me, sir, so that's part of the discussion that my friend and I were seeking to stand this matter down, to discuss how we're going to proceed. So what does it mean to stand a matter down? Well, often the court has multiple matters to deal with, and so something gets called up to be dealt with. Standing it down just says, can we have like a few minutes? Just we'll put this matter back on the shelf, essentially, and we'll come back to it very shortly. Just give us a few minutes, a little bit of time to talk about it. That's all he's asking for here. I just want a few minutes to talk about this. Can I have those? And we'll figure all this out, and I'll be able to come back and give you all the information you want. We'll have this all resolved. So the court says, all right, because certainly I didn't make a note of it. If was said on the record, it would be available for counsel to listen to on FTR. That's the courtroom recording system. So Mr. Levisis says, that's right. And the court says, so is Mr. Ellis available? That's the other prosecutor. And the Crown says, I understand he's in the building. The court says, I saw him outside the building this morning. He walked, and the recording didn't pick that up. So the prosecutor who's in court says, my understanding is he's here right now, and so this issue came up literally minutes before you walked in, sir. So this is why they want to stand it down, right? Is because this issue, is something that they were just in the middle of figuring out and trying to solve and sort out. They're like, we need some time to sort this out. The court says, okay, why is it raised at the last moment? And Mr. Levisis, the defense lawyer, says, probably because I would assume he'd be here for trial. And the court is coming in after him. They're looking for blood here. That's my interpretation of this. The court says, and are you saying on the record? And he says, I. And the court says, no, please don't interrupt me. I want to make sure what you're saying, Mr. Levisis. This is important. So notwithstanding the fact that he was interrupted repeatedly before this, now the court is saying, don't interrupt me. All right. But what they're saying, what the court is trying to do is they're trying to pin him down to saying something so that then later they can hammer him for saying something that's not true if that turns out to be the case. So he says, yes. The court says, so you are saying on the record that Mr. Ellis gave you an undertaking to subpoena this witness. Now, here's the thing. He's trying to remember this. He's trying to figure all of this out, and sometimes there can be misunderstandings. Sometimes you can have one person thought they had an undertaking, like a legally binding promise that they're going to subpoena the witness, and maybe the other side doesn't think they gave an undertaking. This was the kind of thing that they would sort out if they were allowed to stand the matter down. But Mr. Levisis says, oh, sir, I don't have a specific undertaking to that where he signed. And the court says, no, he spoke those words to you and gave that to you verbally? And Mr. Levisis says, sir, I'm going to have to go off my recollection, sir, rather than making misrepresentations to the court, which is something that I don't do, sir. So this is an issue that I'd like to discuss with my friend. And the court cuts him off again, saying, no, I want you to answer my question. Are you saying that Mr. Ellis told you he would subpoena this witness? Yes or no? Let him stand down. Let him get the answer to that. And Mr. Levisis says, my friend has a note to that effect. The court says, no, are you saying that? Mr. Levisis says, I'm sorry, sir, I'm not a witness in this proceeding. And you can see things are getting a little tense here. As the judge says, you will answer my question. And he says, I can't. The court says, you are counsel. You are an officer of the court. You are asking to stand the matter down on the basis that a witness is not present. Are you saying that Mr. Ellis told you? He says, sir, I. And the court says, do not. And he says, sir, I. Do not interrupt me. Well, he's trying to say, listen, if I could stand this down, I'd be able to answer this. He says, I'm sorry, sir. Quiet now, or you will be in contempt. Just be quiet. Answer my question, Mr. Levisis. Just answer my question. He says, no, sir, I. Of course, says, no, do not interrupt me, or you will go into that room in custody. And this is where you get the kind of badass move. He says, okay, then bring me into custody. The court says, no. So Mr. Levisis is like, call. I'll call that. And the court's like, no. And Mr. Levisis says, I don't appreciate how the court is talking to me. And it's my The court says, "You answer my questions, sir." And I'm guessing that their tone was probably harsher than mine, although the transcript doesn't actually carry that through at all. And he says, "No, I'm not going to answer questions in that manner." And the court says, "Take him away." And when I said that there was some cold badassery here, Mr. Levisis says, "Thank you. Let's go." It's got a little bit of the shades of taking off the tie in the Young Thug trial. And the court says, "We're going to proceed with this trial unless I have some information from an officer of the court that the Crown undertook, either verbally or in writing, to subpoena that police officer to testify here today. We will take 10 minutes. So Mr. Levisis wanted to stand this down to have 10 minutes or so to figure this out, but I'm guessing he didn't want to be in cells while that was happening. But that's exactly what happens. He gets sent into cells. Now, I am going to say, Mr. Levisis here was not perfect. There are some flaws, some mistakes that he made, and we're going to talk about those too. But right here, that was messed up. There's no reason to jail him, and I wonder, has he jailed, like this justice jailed Crown prosecutors? Does he talk to them in that fashion? I don't know, but I've got some concerns. There's another case I'm aware of where a defense lawyer was asking for essentially some further out trial dates because he'd booked some time with his family, and the court was very, very harsh. They didn't throw him in jail, but they very much wanted him to cancel his vacation with his family. Defense lawyers often get asked to do things, and they get sort of harsher scrutiny in my view, notwithstanding the fact that we are equal participants in the system, but not always viewed that way. Again, I don't know if that's what's going on here, but certainly Mr. Levisis walked into some fire today. And the question is, did he deserve this at all? So let's see what happens. After the 10 minutes, the court says, "Please bring Mr. Levisis forward. Mr. Levisis, you may return to counsel table." And asks the Crown, I don't know how to pronounce this Crown's name, so I'm not going to try. Apologies. He says, "Have you got any further information for the court?" And this information is really, really important. So the Crown says, "Thank you, sir. I was able to speak to Mr. Ellis." That's another Crown prosecutor, right? So they're both prosecutors, but he went and talked to this other prosecutor and talked to him about any representations made on docket. He agrees that he did tell George Levisis that he would subpoena Constable Hill, and says he did not. And his exact words, "I'm sorry, I dropped the ball." So the judge was spitting fire at this defense lawyer, and it was the prosecutors who dropped the ball. And I mean, the thing is things happen, right? This sort of thing happens from time to time. But in this case, it was a bit of a, the judge wouldn't let them get 10 minutes to sort this out, in which case they would have been able to figure this out and to come to the court and say, here's what happened. This, the Crown said that they'd subpoena this guy. They forgot. That's why we need an adjournment. That's why we've got a problem here. And they might have been able as well this is a situation where they might have been able to make a deal. Maybe the Crown prosecutor comes back and says, "Hey, listen, we screwed up. We didn't bring this witness. We said we'd bring this witness for you. Maybe we'll drop the charges. Maybe we'll offer your client a sweetheart deal." There might have been that kind of negotiation or horse trading. Sometimes that happens, where the prosecution might, feel that they've got a risk of losing the file, because this actually creates the potential that maybe the file gets thrown out for delay or for other things. All of this we don't know because they were never actually given that chance. So, the court comes back with, "Mr. Levisis, I'm going to ask you again. Do you recall Mr. Ellis saying that to you? And Mr. Levisis, who was just thrown in cells for 10 minutes, says, Your Honor, I'm trying to, before I formulate my answer in the most respectful manner and properly, the reason why I was reluctant to answer you is because I don't actually have my physical file. That's my problem. So I'm not trying to avoid answering the question, I just don't have my notes to verify that. Okay, now he really ought to have had his physical file. This is like, why did you not bring this for trial? And yeah, that's not great. Again, things happen, but it's not great. And it's also not great if he was tiptoeing around the lack of his physical file. But again, they would have sorted this out really quickly if the court had just been like, yeah, okay, we'll stand it down. Standing a matter down when it's been called up for trial is not uncommon. It's in fact it's something that happens a lot, because a lot of the time just before trial, Crown and defense might have some discussions and they might say, hey, listen, there's some problems with the case. And they come to a deal, right? A lot of deals are made on the day of trial. And so usually when a judge walks out and counsel wants to stand something down, usually they're all too happy to be like, yeah, don't take too long, but if you want to take 15 minutes, that's fine. So, it becomes a bit of a gong show. And I mean, when I say it becomes a bit of a gong show, keep in mind, defense counsel's probably pretty rattled at this point. He was just thrown in cells for literally nothing he did wrong. The judge was trying to go after him to be like, you didn't subpoena this witness, you should have subpoenaed this witness, when in fact it wasn't his fault. He had a promise that the other side was going to subpoena the witness. He was entitled to rely on that promise. So now he's a bit rattled. And so he says, I don't feel comfortable proceeding on this as counsel on this matter. I'm going to declare a mistrial. Now the court is right here, says, well, you don't declare a mistrial. You can apply to have a mistrial. And defense says, I would seek to apply for a mistrial. There's been several difficulties with this case. This matter has been prolonged for a period of time. Okay. And then the court basically starts trying to reframe what happened. And you can tell me if you think that the things are being described accurately, because I don't. So the court says, we can get to that in a minute. Your application for mistrial. Yes. All right. But I asked a very simple question. Yes. Whether or not you can recall Mr. Ellis saying that to you, and before you said that, you were not going to answer that question, and you would go into custody rather than answer that question. You said, put me in custody. His objections seemed to be over the fact that he was getting just absolutely roasted and not being allowed to finish a sentence, and the sort of the tone and manner in which he was being addressed. And he was just like, no, we're not doing this. And now the court is like, you said put me in custody rather than answer the question. It's like, well, I don't know if that's accurate. And Mr. Levisis says, no, sir, the court says, those were your words, so... And he says, I disagree with that. The court says, sir, don't interrupt me again. Okay. Let me finish, and then you can respond. Sure. All right, it was a simple question. You refused to answer. No, sir, Please don't interrupt me. Well, sir, you will get a chance to respond if you disagree with what I'm saying. It seemed like he finished talking, and then Mr. Levisis was trying to respond. So, I mean, I don't have the timing on the audio, so I can't be certain, but it doesn't seem from the transcript that he was being interrupted. So the court says, this is my recollection of what just happened. I asked you the question, you refused to answer it. The answer could easily have been yes or no, or I don't know, I don't recall any of those answers, but you simply refused to answer. That is where the most recent problem arose. If you want to respond to that, you can, but you don't have to. And he says, I would like an opportunity to reply uninterrupted. Because he's been interrupted a lot. And the court says, go ahead. And he says, if I can have the floor, thank you. The situation is this, sir. I don't recall Mr. Ellis specifically telling me that. What I recall is asking the clerk to, in fact, generate a subpoena, which is what I remember asking Mr. Ellis, saying a subpoena has been ordered through the case management office, is what my recollection is to be. Now, the reason why I requested to stand this matter down, sir, is I'm not trying to interrupt you or lie, but you're putting me in a difficult spot, sir, when you're asking me to respond immediately when I'm not trying to interrupt you and I'm trying to explain calmly. I didn't volunteer to go into custody, sir. You asked me to go into custody. There's a situation now where you said if I don't answer the question, that I'd be sent to custody. And sir, I'm trying to be honest with you. I don't know the answer. I was hoping to talk this matter to my friend, stand it down in a respectful manner, and try to come to an agreement. I'm not trying to play games with you, Judge Yake. This is what I recall, and I just don't feel like I've had the opportunity to clearly explain my position before this incident occurred. And I don't think he was allowed to get 2 words in edgewise. I'm sorry, I didn't mean to upset you in this manner, but I don't believe that I was given a sufficient opportunity to reply, and I was hoping that I would be given or granted the opportunity to at least review my material. I don't have my material with me, so that's the issue. I'm not trying to be evasive. I don't have the physical file with me, so I can't review my documents. I left it at home in Edmonton. The court says, so why wouldn't you bring your file to the trial? And he says, it was an accident, sir. Okay, now, I said that there was some issues and that, Mr. Lebesis didn't do everything perfectly. And one of the things is he applies for a mistrial. He applies to be removed as counsel of record. The court gives him further blowback. I'm not going to read all of that because there's a lot to it. But what ends up happening is something a little unusual after he leaves. So we're going to come back to that. So this is Ms. Derry Gillespie. And you might be saying, where did she come from? Well, the court's going to ask the same question. She says, do you mind if I assist Mr. Van Hel for just the purposes? And the court says, I'm sorry. She says, may I assist Mr. Van Hel today, sir? And the court says, well, no, he is counsel of record. Mr. Lebesis is still his counsel of record. And she says, he is. I've spoken to Mr. Van Hel in Mr. Lebes's absence because Mr. Van Hel, and the court says, I'm sorry to interrupt, but are you instructed to appear as agent for Mr. Lebesis? And she says, not by Mr. Lebesis, but by Mr. Van Hel, who told me that Mr. Lebesis left the building and advised he wouldn't be returning. That's why I'm trying to assist him. And the court is a little perplexed. Well, he's counsel of record. He has an obligation to return. And she says, I shared that information with Mr. Van Hel, but I'm advised that he put on his coat and left, sir. And then, Mr. Van Hel told you that? Yes. All right, just give me a moment. And then addresses the prosecutor, you are on your feet. And the prosecutor says, yes, sir, Mr. Van Hel did come into the room and told me as well. I walked outside of the courtroom to see what I could see. I did observe Mr. Lebesis with his jacket under his arm and his briefcase walk out of the building. And so the court then says, I'm now making an order directing Mr. Lebesis to appear before me on November 22nd in this courtroom at 9:30 in the morning in person, not by WebEx, but in person in the courtroom, and we will take it from there. So the court clearly intends to tear him a new one on November 22nd, which is coming up. I can tell you there's going to be a lot of defense counsel in that room to be in solidarity. I'm not sure if I'm going to be able to, but I'm going to try to see if I can. But yeah. Anyway, they do take Mr. Van Hel off the record, they do take Mr. Lebesis off the record. All of this is a bit of chaos here, and yeah, the reason why I say this is not fantastic is that we have this from the accused. This is, I just wanted to state I have no idea what happened. Me and him had a conversation last night for over an hour about today, and I was not aware of anything on him. I never told him I didn't want him to not be my counsel, so I'm not sure what he's doing right now. And the court says, so you are not applying to discharge him today? And he says, I am, because I don't even know what just happened. And yeah. Unidentified speaker says, he said he's never coming back into this building. And okay. This isn't great. He should have stuck around. He should have addressed this. He shouldn't have fled the courthouse, but I'm guessing he was probably kind of having a rough moment. I'm guessing that this is not how he expected to be spending his day, and I suspect that he was kind of shaken, kind of shook, kind of rattled and battered a bit. So as much as I'm offering some criticism, I'm also offering a little bit of defense and a little bit of explanation, because I'd be rattled too. I don't know if I would have left or whatever else, but I certainly would have been rattled by all of this. And yeah, so I don't know what's going to happen. I'm going to try to follow up on this. There's a lot of people upset by this one, and I thought I'd share this one with you. It is a crazy story. And you're probably going to say, what's this guy charged with? I got no idea. I don't know anything about the underlying file. I just know all of this. To me, looking at this, it looks like this judge came in really hot on the assumption that defense counsel had screwed up and was weaseling and so forth, when it wasn't defense counsel at all who screwed up. And defense was asking for a pretty reasonable thing. He's just like, give me some time. There's a time and a place for a judge to, to tear somebody a new one. Maybe even to send them into cells. Time and a place. I don't think this was the time or the place, but maybe I'm wrong. Let me know what you think, because I got some thoughts. And maybe it's because I'm defense counsel. Maybe it's because, I know the people involved in this, at least a little bit. Like, I know George. I've talked to George. So, I don't know. As I said, his conduct is not perfect, but the judge is really, I think this is a problem. I think this is, I wouldn't want to appear in front of a judge who would treat me like that. And I really think that the respect has to go both ways. The court is saying, don't interrupt me, but equally was not letting him finish a sentence to explain what was going on, and then is really upset that he hasn't explained what was going on. Anyway, that's kind of my thoughts. So thank you guys for watching this one. I'll try to follow up and maybe offer some updates as I can, but thank you for watching. I hope you found this to be interesting or educational. I hope I don't get into trouble for this one. There's always some risk when you criticize a judge, but here I think it's warranted, and I don't think I cut out anything from the transcript that, is unfair to the judge. I think that really this stands and falls on the judge's own words here. So you can make your judgment on that basis. I also want to thank my Patreon supporters at the $50 level, and if you want to join Patreon, there's a link in the description below. $50 level, Bottle Shock and Oz, Canada's National Firearms Association, the CCFR, and the Canadian Shooting Sports Association, PJs Forever, CMP, Cielo, and Purple Dragonair. And at the $20 level, Mark, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunkle of the Baileys, Cameron Johnson, Andrew Elsich, Marvin CZ, and Dorky Dane. Thank you as well to my $10 supporters who will be in the call immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.